Hello, it's Robert Bateman here with another edition of the Privacy Corner, where I talk you through my top 3 picks for privacy developments every week. And thank you, as always, to Privado AI for sponsoring the show. So this week, Meta has implemented a new policy on improving and developing its AI models, and Noyb has submitted 11 complaints about it. So we'll see what they've got to say about that. Controller or processor? Microsoft, according to Noyb, again, is a controller for its education suite of software rather than a processor, and they've submitted 2 complaints about that as well to the Austrian Data Protection Authority. And TikTok and Medibank have both been under investigation preliminarily in one case in Australia, but the Information Commissioner has dropped one case and pursued the other in court. It's quite interesting exploration of Australia's Privacy Act and why it severely needs an update. So first off, Noyb and Meta. Now, Meta, as you might know, introduced a new policy a couple of weeks ago saying it would be training its AI models on your posts. If you are in certain areas, they told you about this and said, we're doing this under legitimate interests and you have the right to object. So I took one for the team and decided to go through the rigmarole of objecting to Meta's processing. And here's what I found. So first of all, you get the standard blurb about what's happening, what sort of data they're using, and so on. It's fairly vague, but not too confusing. They say that you can object under relevant data protection laws, and they will review your requests. So they did a similar thing with their targeted ads. For a period last year. My application to object to that was actually rejected because I'm in the UK, but we'll see how I fared in this context. So first of all, you get the form to fill in. Now, they ask, as they did previously, how this processing impacts you. And it is quite hard to articulate. These privacy issues can be hard to think about from an individual perspective. So I posted on Facebook with the intention of interacting with friends and family. I expressed political beliefs. Oh boy, did I express some political beliefs on Facebook back in the day, and other special categories of personal data in some posts. The secondary use of my personal data is unfair and does not align with my reasonable expectations at the time I made the posts. Now, that isn't really saying how it impacts me. I don't really know how Meta training its AI model on my Facebook posts could possibly impact me. Maybe it wouldn't. To be honest, I told Meta, not a massive issue for me personally, but I just feel kind of weird about it, TBH. So the form then asks you for a one-time password to your email address. Meta does not insist on 2FA in any other context than when you wish to exercise your rights, as far as I know. But security is paramount, of course. So I got the one-time password, submitted my request, and lo and behold, less than a minute later, my request was accepted, and I will not have my posts mixed into the AI training melting pot. Now, Noyb has many, many issues about this new policy, and it says that they arise from a deal with the Irish DPC. So it looks like what's happened is the DPC said, don't do this until we've looked into it. Meta put some mitigations in place, probably stuff they knew they were going to have to do anyway. So a dual notification, this is what Meta calls in-app on-platform notifications, additional transparency measures, a dedicated objection mechanism, 4 weeks notice. They're only using public posts and not comments, and they are not training it on accounts belonging to users under 18. Now, these are not enough for Noyb, as you might expect, and they raise many issues. Here are a few. So Meta speaks of artificial intelligence technology. That's a very broad term, as Noyb points out, could be any number of things. And they also appear to grant themselves license to use pretty much any data on the internet apart from private messages. I think Noyb might be overstating the breadth of Meta's policy here, but the privacy notice is pretty vague, so they are right to capitalize on that, I suppose. The review process is fake, according to Schrems and Co. And they tested it, and the requests were all approved within 50 seconds, even when they said no reasons given. So I feel like a chump for having expressed myself at quite such length in Meta's form, but there we are. I could have just written no reasons given, it seems. So this amounts to a dark pattern, according to Noyb, because it's merely designed to discourage data subjects. They have asked these 11 authorities to act under the urgency procedure because this comes into effect on the 26th of June, and there would not be enough time to deal with a normal GDPR complaint. So, I mean, it's quite robust, and this is quite a hot button issue, of course. So we'll see what they say. I mean, one of these 11 data protection authorities is likely to pick this up. So we could have a battle between Noyb, Meta, the Irish DPC, another DPA, the kind of thing we've seen play out a few times. Noyb normally wins. Next up, Noyb again. I don't cover all their complaints, but these 2 or 13 are quite interesting this week. And there are 2 complaints in Austria against Microsoft. Now, this is all to do with Microsoft's suite of EdTech products. So it's Microsoft 365 Education Package. And you'll see, if you're watching, this delightful illustration from Noyb's website with some discouraged looking children consigning their GDPR rights to the bin. The bin being held open by someone in a Microsoft hoodie. So first complaint is purely about whether Microsoft is controller or processor for these products. And of course, under the GDPR and their data protection agreement, data processing agreement, Microsoft purports to be a processor. But we all know that because of the way the GDPR is set up, we have schools, we have individual people sometimes, one-person businesses using software products where they are deemed to be the controller, and the processor is a huge multi-billion-dollar global corporation like Microsoft. So the liability sits with the smaller actor, and the processor has to obey the smaller actor's instructions. Of course, in reality, that doesn't really work. It's kind of a take it or leave it thing, with all the decisions allegedly being made by the processor. So Noyb's complainant here is the father of a school child, and they submitted an Article 15 request to Microsoft. Microsoft said, no, you have to go to the controller, that's the school. And the head teacher of the school seems to have said, well, I don't know what you're talking about. I don't have this information. So that, for Noyb, highlights the fact that Microsoft is in fact the controller, determining the purposes and means and so on. The second complaint makes a similar point, but in the context of cookies. So in this one, a student set up a Word document in the Microsoft account. A number of cookies were set on their device, and Microsoft is processing telemetry data, 20 requests to 2 Microsoft domains. Microsoft's documentation suggests that some of these cookies are used for advertising and analytics and tracking and so on. So Noyb says that Microsoft is liable for allegedly placing these cookies without consent. Now, a lot of Noyb's complaints go against the smaller actor. We had 101 complaints against websites implementing Google Analytics or the Meta Pixel after the Schrems 2 decision. Here they're going for the big guy, Microsoft, and that could be a potentially more effective approach. But of course, it presents the additional hurdle, a very fundamental hurdle of proving that Microsoft is showing that Microsoft is the controller. So it's a pretty interesting case, and it would change a lot, I think, if Microsoft was found to be the controller in respect of these products. Finally, Australia. Now, the Office of the Australian Information Commissioner is pursuing a civil penalty against Medibank over a data breach in 2022, but has decided not to pursue TikTok after some research about their tracking activities got a high profile last Christmas. So the TikTok case, this was some research by an NGO, And the OAIC, the regulator, got a number of inquiries about it. And the commissioner there, Carly Kind, she is very disapproving of what TikTok does, but she does say other social media platforms do it too, of course. But she says Australian law does not cover this. The Privacy Act 1988 is a very old law. A lot of privacy laws are quite old, but they've been updated over the years. The Privacy Act has a bit, but not very much. I mean, it's pretty archaic. It's very narrow. It doesn't apply to everyone. It doesn't. It misses a lot. So she says we need reform of this law urgently. Now, that reform has been ongoing for some time. I've been reading about it for years, but it still hasn't happened. There was a Privacy Act review reported in 2022. Last month, the government said it was expediting the recommendations in that report. But as it stands, the Privacy Act in Australia is very out of date. Now, the other case, though, is more straightforward under the Privacy Act of 1988. It's Medibank, and you might remember in October 2022, they had a huge data breach that's a healthcare provider affecting 9.7 million Australians. That's a large proportion of Australia's population. And the regulator is applying for a civil penalty in the federal court. Now, again, in this context, the maximum fine under the Act is $2,220,000 Australian dollars, so about $1.5 million US dollars, I think, and that's per violation. So I don't know in Australia whether that means per breach or per individual whose data was breached. If it's the latter, that's obviously going to be a lot of money. If it's the former, then that's another example of why this law really does need reforming. So that's it from me this week. Thanks so much for your time and attention. I've hosted some roundtables for Provido over the last few weeks. They've all been great fun. London on Wednesday was really good to see everyone there. Do look out for future events if we hold them, and I'll see you all next week.